Hello viewers, myself is Cheena Brol, Assistant Professor, School of Law, City University, Ludhiana. Today I am going to present on the topic crime and its essential. So before discussing the concept of the crime, firstly I would like to share about the what is the lectures outlines. So the lectures outlines is about the instructor information, course objective, course outcomes, then we discuss about the crime, its introduction with meaning and definition part, then what is the essentials of the crime and what will be the conclusion at the end. This is the course outline of the concept. After that, what is the course objective of the crime and its essential, in which we will discuss about the conceptual understanding of the specific principles of the criminal law, and we can also apprise the concept of the different types of the offences under the Indian Penal Code 1860. To enumerate the concept of the crime and its essential, under which we will discuss that what is the concept of the crime, how the crime emerged, from where the crime came, and what are the basic essentials and the characteristics of the crime. So these are the objectives of this unit. After that, now we will discuss what are the course outcomes. The course outcome consists of the different principles of the criminal law, what are the basic principles and the guidelines of the criminal law, and we can, on the basis of that, we can enumerate the concept of the crime and its basic essentials, ingredients and objectives, and the information related to the crime and its elements. Then we will demonstrate the different types of the offences which are done by the offender. So basically these are the course outcomes of the crime and its essential. Now further we will start with the crime and its essential. Firstly we will discuss about what is crime. Crime is an act which is punishable by law as forbidden by the statute, or which is injurious to public welfare. So crime, it is an act which is prohibited by law. The law which give not give the provision to the concept. Anything which is injurious to the public welfare as a crime, and anything which is injurious to the public welfare is a crime. So crime is basically an act, an offence which is punishable by law, law which gives the penalties, and all kinds of the punishments and the penalties are prescribed under the Indian Penal Code. So there are the different concepts related to the crime. It is an act which is done by the human being with the violation of crime. When you violate the law, now the question is, what is law? Law is basically the rules and regulation, and that you will have to follow in this society. But if you are violating that law, it means you are criminal, you are doing the offense. So offense is always, and crime is always, an act which is punishable by law and which gives the injuries to the public welfare, which is opposite to the injury, which gives injury to the public. Now the concept of the crime basically gives the different kinds of the definitions given by the different jurists. Now there is a very well known jurist, that is Bentham. Bentham gives the definition of the crime. He said that offences are whatever the legislature has prohibited for good or for bad reasons. Means offences or crimes are those which the legislatures made. Legislatures are the law making body, and they also makes the prohibition for good or for the bad reasons. So according to Bentham, this is the basic main definition of the crime. Now another jurist also gave the definition related to crime, that is the Blackstone. Blackstone is also a very famous well known jurist. According to Blackstone, violation of the public rights and duties due to the whole community considered as a community in its social aggregate capacity. According to Blackstone, he considered crime that if there is the violation of the public rights, if there are the public rights that are violated and duties due to the whole society, and the duties that are related to the whole society, and these duties are considered as community in its social aggregate capacity. So, all these things all these acts which are prohibited by law, where there is the violation of law, where there is any kind of the prohibition in law, all that acts will be considered as crime. So, now you know about what is the definition of the crime. Crime is that thing in which you have some restriction not to do that particular work. If you did that work, it means you are violating the laws, means if it means you are violating the rules and regulations. So, an act which is punishable by law, any kind of offence which is punishable by law, which is prohibited by law, is known as the crime. So, now the question is what the crime includes. What are the different things which makes that this is a crime. So, crime includes basically 4 elements. It is made of 4 features, or you can say it is made up of 4 essential. The main 4 essentials of the crime are human being, evil intent, act committed and injury. So, if these 4 essential elements are there, it means it is a crime. So, crime, all of you know, crime is an offence which is punishable by law. Now, what type of things that should be included in crime? So, crime is the inclusion of these 4 things. First is human being, then evil intent, then act committed, then injury. Now, we will discuss one by one all these concepts. So, before discussing these essentials, firstly we will start with the modern approach to the crime. What is the modern approach related to crime? The basis of the criminal law is that there are certain standards of behavior, of moral principles which society requires to be observed, and the breach of them is an offence not merely against the person who is injured, but against the society as a whole. The main criteria of the criminal law is that there are some basic standards, some basic moral principles are there, which the man is a social man, he is living in the society, which the man will have to live in the society and they will have to observe it. But if you are breaching them, if you are not following them, it means you are committing the offence and you are the culprit, you are considered as offender. So, this is the basic criteria of the criminal law. So, theoretically a crime is a threat to every member of the society. Crime is a threat which is given to every member of the society, even though it may be in reality an offence only one specific person. If it is an offence, if it is a crime only related to the particular person. So, thus what a man does in private is not the law concerns, unless it can be shown to be contrary to public good, that law ought to be intervened in its function as the guardian of the public good. So, anything if you are doing in the public interest, anything which if you are doing in the public welfare, then it is not the crime. Crime is that if there is the violation of the law, if you are not obeying the law, if you are disobey the law. So, all these things makes the term crime. So, this is the basically modern approach to crime. So, next, essentials of the crime. What are the basic ingredients, essentials and elements of crime? So, next we will discuss about the modern approach to the crime. So, what will be the modern approach to crime? The basis of the criminal law is that there are certain standards of behavior, of the moral principles which the society required to be observed. So, all of you know that man is a social animal. He lives in a society, and in society when you are living you will have to follow some principles, you will have to observe some rules, and if anyone is breach of that rules and regulation, this will be considered as an offense, not merely against the person who is injured but against the society as well. So, theoretically a crime is a threat to every member of the society. So, it gives a threat to every member of the society, even though it may be in reality an offense against only one specific person. And thus what a man does in private is not the law concerns unless can be shown to be contrary to the public good, that the law ought to interfere in its function as the guardian of its public good. So, modern approach related to crime is that there are the some basically standards and the principles that we will have to follow when we are living in the society, and if you are breaking all these principles, rules, regulations, setups, then it will be considered as an offense. So, after that now we will discuss about the what are the main elements of the crime, what are the main essentials of the crime. So, basically crime includes the four elements. The first one is human being, then the second one is evil intent, mens rea, third one is actus reus, and the fourth one is the injury. So, human being is a human being under a legal obligation to act. When a man does any act under the legal obligation, he will be considered under the definition of human beings. Human beings here means he should have the body. An animal is not considered as a human being. Corporations are not considered as the human being. Artificial persons are not considered as the human being under the concept of crime. Second one is mens rea. Mens rea means guilty mind. It means if you are having the wrongful intentions, means your intentions are not good. Basically there are two types of intentions, good intention, bad intention. So, where there is any wrong intention, where there is any bad intention, and if you are doing any act, then it will be converted into that act will be converted into crime. And the third essential is the actus reus. An act committed or omitted in furtherance of such an intent is called as actus reus. Means if you are committed an act in furtherance of that such an intent, with that intention, with that wrongful intention, with that guilty mind, if an human being is doing any act, this is the third essential ingredient. The fourth one is the injury. Injury means any harm given to the another person. When an human being does any act with wrongful intention, with guilty mind, with mens rea, and injury is given to the other persons, all these are the four basic ingredients or the elements of the crime. Now, we will discuss one by one the what are the first element of the crime, that is human being. Human being means an act must have been done by a human being before it can constitute a crime punishable by law. So, in ancient criminal justice system, punishment was inflicted upon animals or inanimate objects for the injury caused by them. For example, Baring Gold's Chorister's of olden times states that if an ass has been found grazing in a field that is not of its owner, then one of its ears were chopped off, and if it repeats the same thing with same mistake, then the other ear is also chopping off. But with the development of the concept of the mens rea as an essential element, punishment on animals and the object has been withdrawn, and crime is only related to the human being, not upon the animals, corporations or the other artificial persons. So, crime can be committed only by a human being. This is the main first essential element characteristics of the crime. After that, we will discuss with the second essential, that is mens rea. So, mens rea I already told you, where the guilty mind is here, means if you have the guilt in your mind that you have committed something wrong, means your intention is not good at the time of the commission of the offense, and you are having the wrongful intention, you are having the bad intention, this amounts to mens rea. So, mens rea basically deals with the very well known maxim actus non facit reum nisi mens rea, which states that the act itself does not make a man guilty unless his intentions were so. And it is already connected with the another maxim, which means actus meus me invito factus non est mens actus, which means an act done by me against my will is not my an act at all. If an act is done by me, but if it is against my wishes, if it is against my will, then it will not be my act. So, intent and the act both must concur to constitute the term crime. So, these are the second essential element of the mens rea. So, we will discuss the concept of the mens rea with the case laws. There are very important landmark judgments related to the mens rea, which denotes that the mens rea concept should be there, and which involves that there is the involvement of the crime. The mens rea deals with the wrongful mind, and the R versus Prince is the landmark judgment related to the mens rea. In R versus Prince, the prisoners have taken and enticed the child that was below the 16 years of age from the custody of her father, will consider as an offence under the Offence of Prisoners Act. In this case, mens rea was there, guilty mind was there, wrongful intention was there, and he was considered as an offender under the law. So, mens rea, for the concept of the mens rea, you can go for the R versus Prince case law. That was the well known landmark English case law, and it was held that mens rea necessary for the criminal liability should be required to consider it as a criminal act. There is also another case law related to mens rea, that is Queen versus Tolson. This is also the English case law, and in this case the husband and wife, they married each other on 11 September 1880, but on husband deserted her wife in December 1881, and he went to the America for shipping. And in December 1881, the wife came to know about that ship that husband got missing, and after 7 years of her marriage, that is on December 87, she was married again. But in after that, after some time period, when she married, the husband came back in December 87. He came back and he just put a case against the against her wife that she has committed the offence of bigamy. Bigamy is an offence under the Indian law, and Indian law states that if a man or husband commits more than one marriage, it is an offence, and there is the punishment in the IPC. But in this case, mens rea was considered on that ground that at that time when she remarried again, her intention were not the bad intention. Her intention was good intention, and she will not be penalized, she will not be punished under the offense of the bigamy. So, mens rea, for the concept of the mens rea in Queen versus Tolson, the court majority held in bona fide belief in reasonable grounds as to the husband's death, and the death was defense to the bigamy. Therefore, remarrying after assuming that her husband has died does not constitute bigamy. Here mens rea was absent, and therefore she was not held liable. So, wife was not held liable only on the ground of the mens rea. She knew that thing, that she was having the good intention at the time of the committing of the second marriage. So, she has not committing the offense of mens rea. Now, we will discuss about the third essential of the crime, that is actus reus. Actus reus, it is the physical element of the crime. It means it refers to an overt act or omission of a duty. When you are doing a duty, when you are committing a duty, when you are doing any kind of act, it means actus reus should be there. So, without any actus reus, a crime cannot be constituted. If there will not be commission of any act, then crime will not be there. So, actus reus is the main essential element of the crime. If a person has an evil intent to do a crime, he must act for its commission. With mens rea alone, it is impossible to call it as a crime, as no one know about the intentions of the man. So, for doing any kind of act, you cannot say that there is a crime. For the commission of crime, act should be there. Act means any physical element of the crime, means an overt act or omission to duty. So, this is also the main ingredient of the actus reus. Last is, but not the least one, the fourth ingredient is the injury. Injury, I already told you, that is the harm. For the creation of the offense, when an act is done by the human being with wrongful intention, and if that act, if the harm is given to the other person, to the other party, then all these essential constitute the term crime. So, if a human being acts with evil intent and the act must inflict an injury, the word injury is defined under section 44 of the Indian Penal Code 1860, and it defines injury as any kind of harm whatever illegally caused to any person in mind, in body or reputation or property. So, injury can be done against the mind, against the body, against the reputation or goodwill or the property. So, all these things, these are the inclusion of the crime. Mens rea, human being, actus reus and the injury. All these concepts, whenever they will be there, it constitutes the term crime. So, in the conclusion, now I would like to conclude my topic. In the end, we can say that crime is an act which is punishable by law. It is considered as an offense which is prohibited by law, and Indian Penal Code 1860, it imposes fines and punishment related to the offense. If any offender commits any offense or crime, then there are the punishment, and all the punishments are prescribed under the IPC, that is Indian Penal Code. So, to constitute the term crime, the main four essentials make it proper, which is the violation of law. So, whenever there will be any violation of law, whenever there will be any set of rules of law rules and regulation, whenever there will be any violation of the law which are made for the welfare of the public, it amounts to crime. So, with this I am conclude my topic, and if you have any queries, you can join with my email ID that is already shared in the site. Thank you.